Section 14 in the Foreign Exchange Management Act, 1999. 14. Enforcement of the orders of adjudicating authority. 1. Subject to the provisions of subsection 2 of Section 19, if any person fails to make full payment of the penalty imposed on him under Section 13 within a period of 90 days from the date on which the notice for payment of such penalty is served on him, he shall be liable to civil imprisonment under this section. 1. Subject to the provisions of subsection 2 of Section 19, if any person fails to make full payment of the penalty imposed on him under Section 13 within a period of 90 days from the date on which the notice for payment of such penalty is served on him, he shall be liable to civil imprisonment under this section. 2. No order for the arrest and detention in civil prison of a defaulter shall be made unless the adjudicating authority has issued and served a notice upon the defaulter calling upon him to appear before him on the date specified in the notice and to show cause why he should not be committed to the civil prison, and unless the adjudicating authority, for reasons in writing, is satisfied. A. That the defaulter, with the object or effect of obstructing the recovery of penalty, has after the issue of notice by the adjudicating authority, dishonestly transferred, concealed, or removed any part of his property, or b. That the defaulter has, or has had since the issuing of notice by the adjudicating authority, the means to pay the arrears or some substantial part thereof and refuses or neglects or has refused or neglected to pay the same. 3. Notwithstanding anything contained in subsection L, a warrant for the arrest of the defaulter may be issued by the adjudicating authority if the adjudicating authority is satisfied, by affidavit or otherwise, that with the object or effect of delaying the execution of the certificate the defaulter is likely to abscond or leave the local limits of the jurisdiction of the adjudicating authority. 4. Where appearance is not made pursuant to a notice issued and served under subsection 1, the adjudicating authority may issue a warrant for the arrest of the defaulter. 5. A warrant of arrest issued by the adjudicating authority under subsection 3 or subsection 4 may also be executed by any other adjudicating authority within whose jurisdiction the defaulter may, for the time being, be found. 6. Every person arrested in pursuance of a warrant of arrest under this section shall be brought before the adjudicating authority issuing the warrant as soon as practicable and in any event within 24 hours of his arrest, exclusive of the time required for the journey, provided that if the defaulter pays the amount entered in the warrant of arrest as due and the costs of the arrest to the officer arresting him, such officer shall at once release him. Explanation. For the purpose of this subsection, where the defaulter is a Hindu Undivided Family, the Karta thereof shall be deemed to be the defaulter. 7. When a defaulter appears before the adjudicating authority pursuant to a notice to show cause or is brought before the adjudicating authority under this section, the adjudicating authority shall give the defaulter an opportunity showing cause why he should not be committed to the civil prison. 8. Pending the conclusion of the inquiry, the adjudicating authority may, in his discretion, order the defaulter to be detained in the custody of such officer as the adjudicating authority may think fit or release him on his furnishing the security to the satisfaction of the adjudicating authority for his appearance as and when required. 9. Upon the conclusion of the inquiry, the adjudicating authority may make an order for the detention of the defaulter in the civil prison and shall in that event cause him to be arrested if he is not already under arrest, provided that in order to give a defaulter an opportunity of satisfying the arrears, the adjudicating authority may, before making the order of detention, leave the defaulter in the custody of the officer arresting him or of any other officer for a specified period not exceeding 15 days, or release him on his furnishing security to the satisfaction of the adjudicating authority for his appearance at the expiration of the specified period if the arrears are not satisfied. 10. When the adjudicating authority does not make an order of detention under subsection 9, he shall, if the defaulter is under arrest, direct his release. 11. Every person detained in the civil prison in execution of the certificate may be so detained. A. Where the certificate is for a demand of an amount exceeding rupees 1 crore, up to 3 years, and b. In any other case, up to 6 months, provided that he shall be released from such detention on the amount mentioned in the warrant for his detention being paid to the officer in charge of the civil prison. 12. A defaulter released from detention under this section shall not, merely by reason of his release, be discharged from his liability for the arrears, but he shall not be liable to be arrested under the certificate in execution of which he was detained in the civil prison. 13. A detention order may be executed at any place in India in the manner provided for the execution of warrant of arrest under the Code of Criminal Procedure, 1973, 2 of 1974,